We might as well get started. Our next speaker is Lisa Feld. Lisa's a partner at Feld, Handy, Houston, and she practices in the area of litigation and alternate dispute resolution. She is currently involved in the evaluation study of the ADR Center, the court-connected one in Toronto. She graduated from the University of Windsor, was called to the bar in 1990, was from July 1992 through to May involved in sole practice, providing dispute resolution services, training, education, and consulting. She was appointed in May of '93 a visiting scholar at the program on negotiation at Harvard Law School, and also was a recipient of research grant from the Ontario Fund for Dispute Resolution. Currently, she is a special lecturer for the University of Windsor's Faculty of Law, teaches a course on theory and practice of alternative dispute resolution, and Lisa will be speaking about ADR in the health law setting.
Great. Good morning. ADR is a term that is sort of overused and misused, and that's sort of what's great about it. It encompasses so many different models and policies and procedures that there's no one single term I can tell you that will give you the end-all, be-all definition. But what it stands for is the idea that there are different ways to resolve conflicts other than going to the traditional routes such as litigation or arbitration, which is usually the ones where we see people using their rights to fight against other people's rights. And I included in my materials what the Law Society so helpfully put together a couple years ago, which is a glossary for ADR terms, which some of us use as one guidepost, so we're all talking the same language. And I wanted to just take you to the ADR spectrum, which is at D-43 in the materials. And most of the time, we are in that last row of adjudication, looking to a third party to tell us who is right and who is wrong. And what alternative dispute resolution is now challenging us to do is to not only move up one row, but to move right up to the top left-hand corner and look at what can we do to help either avoid disputes or negotiate disputes, or even at the sort of farther right-hand side, use processes such as mediation, which are facilitated negotiations, instead of having to creep down to the other two rows, because when you do that, the process becomes more expensive, more time-consuming. It takes the decision-making away from the parties, and usually has more detrimental effects on the parties' relationships. So the challenge is to keep what we need to do up in that top row. And if you, there's a sort of a cute little anecdote in Roger Fisher's book, Getting to Yes, which is seen as probably one of the sort of predominant, easy-to-read books in ADR that came out of the Harvard Negotiation Project. And he talks of two children standing beside the refrigerator arguing over the last orange. And the parent comes to deal with it and notices, nope, the two kids are yelling. The easy thing to do is just cut the orange in half. And the kids continue to yell and scream and be upset. Then the parent asks, well, what's the problem? Obviously, you each have a half. That's got to be the best way out of this. And one child says, but you don't understand. I wanted the orange because I wanted to make a cake and I needed the whole rind of an orange. The other child says, you didn't ask me. What I wanted was the whole flesh. So this is the challenge we have, is to be the parents of these type of children and take the time to find out that their interests were something that could be dealt with in a way other than just slicing the orange in half. And one of the most interesting programs that has applied ADR techniques is right here in our own backyard, the one that was implemented by the College of Physicians and Surgeons, now going on to, I guess it's about its 4th year of experimentation. It's unique in North America and being studied around the world as the first time ADR techniques that have taken a bit of what we know from labor management, a bit of what we know from commercial arbitration, a little bit of what we know from family mediations, sort of looked at all those different ones and then created one especially for a situation where a complainant has made allegations of misconduct against a physician, and rather than taking the traditional routes of watching that go through the statutory committees and end up at a discipline hearing where the complainant no longer has party status, where the parties have no control over the outcome of the case, the college, under, well, it was a little bit of political, a little bit of financial, all different forces upon it, decided to take a step back and say, rather than continuing taking these cases to the discipline committee, especially because they had the pressure of the sexual abuse task force cases, let's see if there's some other way of dealing with these cases rather than having the formal hearings. And for the first time, they brought in outside neutral mediators, people who did not have an interest in the outcome of the case. We were not interested as a prosecutor. We were not interested as defense counsel. We were not even interested in the college's point of view necessarily. We were people skilled in negotiation process. So we had the opportunity to actually ask the complainant, why did you come to the college? What were you trying to get out of this process? What did you think the college would do for you? And you'd often get the answers of, well, we didn't want it to happen again. We just wanted the doc to know that, we were really upset when she didn't tell us Dad was so sick, or when Dad died, didn't explain what happened. And we just want to know that somebody's going to make sure that this doc knows how upset we are and it's not going to happen to another family. On the physician side, not surprisingly, she was quite thrilled that a discipline hearing was not set and she wasn't going to need someone to defend every step that she made in the case. And more importantly, both parties now had the opportunity to custom make a particular resolution for their case. They didn't have to just stick with the penalties that a discipline committee was looking for. So you had physicians give either verbal or written acknowledgments. They offered to take courses, look at upgrading, write articles, attend lectures. Some of them even did community and charity work. Sometimes all the parties needed was a facilitated meeting where they could ask questions, have questions answered, give a little speech on behalf of the family, or just even have the opportunity to cry or scream at the physician if that's what the family needed to do. The other interesting part of this model was the college had to figure out how to put the public interest at the table. They realized it was there throughout the legislation. It was their statutory duty to protect the public interest, but where do you fit this into a mediation table? And this was actually the exact problem that the College of Nurses had in Alberta when they first experimented with using mediation. These agreements weren't quite working out because no one was supervising the entire process. So the College of Physicians and Surgeons decided that they would actually physically have a representative of the college, in this case a staff person, be the one with the public interest at the table. So even if the physician and patient could work out and come out with a particular solution, there may be other things that the college was looking for, such as monitoring or supervision or another undertaking from the practitioner beyond just what the complainant and the family wanted. This also allowed the college to sort of hook in the physician to a complete undertaking, and in case there were ever any problems, the college made sure that they could come back and deal with a breach of the undertaking or use the agreement in another discipline hearing in the penalty phase if indeed that ever happened. The success was quite outstanding. They were careful to choose cases that looked like they would be amenable to ADR, and they had an overwhelming success rate of approximately 85%, which is very, very high for an ADR program. Just comparing that to the ADR Center in Toronto, which had a 50% success rate for their types of cases. They also had no problem with compliance from the physicians. What has now, and I sort of call that sort of the first phase of the model, the college is now reviewing those cases, the type of model that was being used. There were definitely lots of problems with that particular model. It still took longer than it should have, although it took a lot less time than discipline hearings. It was still a little more expensive than the college had wanted. It was ranging from about $3,000 to do a mediation as compared to about $30,000 to do a discipline hearing. But the college is now reviewing their entire process to see what else can we do other than this particular mediation model. So what I call sort of the next stage of what's happening in healthcare ADR, in many ways is happening from this particular project. And one reason that's happening is the college decided to publish the outcomes of the mediations. So in their members' dialogue, once a month, you get to read about some of the discipline cases. If you turn a few more pages, if you're still reading, you will find the ADR resolutions. And there's no names or any other identifying information, but they'll give a little blurb about the complaint and then take you through to the end to give you the creative solution that the parties came up with. And what is happening with those cases is they're starting to get to physicians who are teaching in medical schools, and they are not only, again, demonstrating how important it is to communicate well with your patient, and once there is a problem, here's some ideas of dealing with it, but they're starting to think about teaching these particular skills to their physicians. We've actually, my firm in the University of Windsor does a joint venture in certificate courses, and we're doing as we call it, a part 2 this week, and there's a couple physicians in this particular course. And I asked them late yesterday afternoon, so why are you here? What would a physician need negotiation and mediation skills for? And they had sort of 5 or 6 different examples. Well, we want to use it when we've got an elderly patient and the family is not getting along or fighting over what to do. We want to learn the skills as physicians, how to facilitate a better meeting among all these people. There was the use of problems with compliance with medication. Physicians want to learn a different way of negotiating with someone either who is not taking their medication, or when they go home, the family says, oh, you don't need that stuff, don't worry about it. They want to use it when they've got problems among staff and teams, now that there's a sort of a movement to have every different member of the healthcare team work on a particular problem. That's not always easy to do when the physiotherapist and the pharmacist and the physician already feel there's some power indifferences. These physicians want to say there's got to be a better way when we sit down to look at a patient to decide how to process that information. They're looking at using it for research committees. They're looking at using it for ethics committees. So we're actually getting the practitioners now looking at what other ways can we deal with the problems that we currently have in a way that doesn't make it look like I'm right and you're right. We have to keep arguing about it until somebody just gives up because the argument is either too tiring or too expensive or too costly. Other regulatory colleges, the College of Nurses, for example, is using a mediation process to deal with their fitness to practice cases. Again, when they examined this particular model, they said, we really like it, but our discipline cases are really important. They have to go ahead, so we don't want to use it there. So they're now using it in the fitness to practice arena as a way of getting compliance, voluntary compliance, from the practitioner to do certain things without the necessity of the full formal hearing. They're also using it before complaints committee, again in a voluntary way, just like the College of Physicians and Surgeons. No one was forced to look at the mediation model. It was all done on a voluntary basis. The College of Nurses said, we want to use it way before we even get a complaints committee involved. So they use it and they call it, it's called PRP, Participatory Resolution Program. See, everyone likes to have their own acronyms and fancy names. They all try to outdo each other with model names. And they use an internal person, so one of their investigators is designated as someone who enjoys and is now educated in this type of work to work with the complainant and the practitioner, again, to facilitate a custom-made resolution. Especially in those cases, you're going to get the third parties involved. You're going to get insurance companies involved or the hospitals involved, so everyone's sort of learning this as the first time they come into the process. The other new arena for this has been the sexual abuse cases. Now, the College of Physicians and Surgeons at this point is still in the let's study it stage, which I completely respect. You need to be very comfortable with the model before you move it in to more difficult cases. But at least 2 of the other health professions have been, and for both of them have had at least one each has had now quite a successful case in what usually would have been a full discipline hearing for sexual abuse matters. Now, to be fair, these were not what we would call the more serious cases. It's the ones that probably, but for the new amendments, probably would have fallen into just general misconduct and unprofessional behavior, either improper touching or improper words used during an examination. And so both of these colleges, I think, took a calculated risk. Both the complainants had legal counsel, which they don't necessarily do in other processes. And I think they will continue to use this model, again, if everyone volunteers. And in both those cases, again, with some security measures in place, they had psychiatric assessments done on the practitioners before they even made the invitation for them to participate in a mediation. That was their way of saying, before we even let you go, we want to make sure this was hopefully an isolated incident, or if there's something else about your personality or your practice that we should know about before we let you into this voluntary process. So it is starting to move into arenas that nobody quite expected it to go into. The other parallel that's been going on is for some cases at these, at some of the cases at the regulatory colleges, they have parallel civil cases going on. And what happened at the CPSO, the first few times everyone said we can't do a mediation, or we don't even want to have a discipline case while the civil case is going on, or sometimes they wanted it first as a way of having free discovery or having a finding. What started to happen is as the lawyers and physicians and patients' families and lawyers started to learn more about each other, not only about each other's case, they started to say, if we can figure out this discipline hearing problem, let's see if we can use the same process to work out the civil suit. And there's been, although the college stays away from that, there's great anecdotal stories that come back to us to tell us that that's happening in a tremendous amount of cases. There's a little bit of give and take that if we deal with the mediation on the discipline, that will help your civil case. Again, college stays out of it, but again, the lawyers and the clients are learning about the process in the civil arena. The same thing was happening as the ADR Center opened, and although most of the cases that went through there were wrongful dismissal, there was a good handful of medical malpractice that ended up there. And the first few, because it was happening pre-discovery, were adjourned because people wanted expert reports. But as they start to get a little more comfortable with the cases, some were willing and did settle without expert reports being exchanged or having any discussions and questions about it. So as each party is going through different processes, we're starting to make the mediation process better and more adaptable to the healthcare setting. And I think when I keep listening during the Creever inquiry, when the parties are begging for an apology from the Red Cross, it's a perfect example of watching a process that's looking at everyone's rights, completely forgetting everybody else's interests. And although we all know, all those of us who practice law know that capital A apology is never something you can give because it admits so much with it, you learn that there are many, many ways to apologize and acknowledge without giving the capital A apology. And it's quite striking that that's still something that these parties are looking for in that arena, and nobody can give it to them because we're so stuck in a rights-based process. So we still have so far to go in the system that is trying to take care of people's rights, but completely forgetting their interests. So as hospitals now start to look at having ombudspersons, as hopefully the medical schools start to look at better ways of helping their students negotiate when they have to deal with their patients, I think we'll start to learn that although ADR and mediation is not necessarily therapy, it can be extremely therapeutic and an excellent, excellent tool to use in the healthcare field. I think the challenge is just to be creative. There are really few rules. The terms are all over the place. You can learn from the banking ombudsman and use that in the hospital setting. So try to be very Canadian and be unique. We have a lot to share in this arena that we're not sharing with each other. And I think the challenge as lawyers is to say to our clients, that we know there are some better ways. I'm not worried about losing money. I can show you lots of articles to prove that you don't lose money if you practice and offer ADR to your clients. Just make sure it's something that is appropriate for them at the time, and take the time to even create the proper model that your particular clients will need. Thank you.
Thank you very much, Lisa. We're now going to turn to the issue of ethics, and certainly the role of ethics in the provision of healthcare is becoming more and more pronounced, and certainly as council, we involve ethicists more than we have ever before. Dr. Hebert obtained his medical degree from U of T in 1984 and is trained in family medicine. In 1983, he completed a PhD in philosophy at York University. He's assistant professor in the Department of Family and Community Medicine at Sunnybrook, member of the executive of the Joint Center for Bioethics at the University of Toronto. He chairs the hospital, that's Sunnybrook again, the Ethics Committee and the Research Ethics Board, and as of July will be the interim director of the Clinical Ethics Center. His new book, just out a few days ago, Doing Right, A Practical Guide to Ethics for Physicians and Medical Trainees. Dr. Hebert.
Thank you. Thank you for inviting me this morning. It was hard to know how to pitch my remarks. I trust most of your lawyers, I usually speak to physicians. I think this is an exciting time in medicine. I think medicine, law, and morality are all learning from each other at this time. There are some people who think the interests of these different disciplines are opposed. I don't share that view, and I think there is a fruitful interplay here. I think one of the difficulties for physicians or healthcare practitioners generally, when faced with novel forms of dilemmas and problems in the care of medicine, is knowing what standard of care they'll be held to, and especially what is the ethical standard of care, and that is always some difficulty knowing exactly what that is. I think in part the ethical standard of care does rely upon law, but I don't think law is exhaustive of one's moral responsibilities. And there's an evolving standard of care in many areas, and I want to talk today about some cases that look at that. So I'm going to talk a little bit about, just going to start with a case that's very typical of moral dilemmas that practitioners face in the trenches every day, and why there are ethics consultants now involved in many hospitals, certainly many teaching hospitals, to try to resolve these problems. I want to talk a little bit about medical morality, 4 recent legal cases, one of which has already been touched upon, therefore I won't deal with it very much this morning. I'll talk about some ethical standards of care that arise out of these cases, and then just mention briefly at the end something about ethics resources and their limitations. Well, this case is a recent one we had at Sunnybrook, and I have changed it, but the substance of it is the same, and it is actually in your handout. Concerned a woman in her 60s who had a previous stroke and hemorrhage and was bed confined, and had virtual quadriplegia, although she had some use of her hands. And she came into the emergency unit with an intentional drug overdose. Was in respiratory failure, required ventilation. However, she was alert enough to refuse this in the emergency room, citing her poor quality of life and that she had never wanted this. And she in fact said she had a living will, although nobody had access to it at that time, that documented her prior refusal of ventilation. And the physicians, especially those in emergency, faced with a woman who, unless she received immediate ventilatory support, would die, were in a bit of a dilemma. They felt, well, on the one hand, a desire to respect her wishes, her autonomy. They also felt that they had to be careful and cautious here, that they weren't assisting her in suicide, and were in some difficulty knowing exactly how to proceed in this case. I'm not going to tell you what our answer to that case was, perhaps we can talk about it. But I think this is very typical of the dilemmas that we, or maybe somebody here has the right answer for me and can tell the right answer in this case. I think this kind of case reminds us, however, something about moral dilemmas, especially in a professional setting. And someone in a legal case, by the way, if someone knows what legal case is from, I'm very interested in what it's from. I read it somewhere, and it's not my phrase, that a hospital is not a hotel. Although increasingly with, in economically tight times, hospitals are becoming a lot more like hotels with charging for various things, not quite like the States where they charge each piece of toilet paper you use, but may become that way. However, there is a certain However, a hospital isn't a hotel, and we certainly have an interest in what goes on behind closed doors. We don't just give people room and board. There's a certain expectation that we have of practitioners in that setting that they'll approach cases in appropriate fashion. And what is the appropriate fashion, especially when faced with a case like this that raises a lot of difficulties for people. And this is rather typical ethical dilemmas about what we should do. There are no hard and fast rules that are going to tell you what the right thing to do is. There's no moral algorithm that's going to say, well, you weigh up this principle and that principle, and this tells you the right answer. And this creates a great deal of difficulty for healthcare practitioners. Well, ethics, some people ask what's the difference between ethics and morality, and I won't spend any time on this, but just to suggest that ethics is considered reflection, whereas morality is how things are actually practiced in the day-to-day world. Actual morality or the mores of people in a healthcare setting may or may not be appropriate. Ethics is that more considered reflection on what should be done, a considered reflection which healthcare practitioners don't often have when faced, say, like as with that patient who's going to die unless ventilated. Well, I think ethics can help in the proper resolution of such cases. There are better and worse ways of handling such dilemmas, and one way is certainly to look at the standards, that the precedents in the literature and in law and in ethics as to how such cases can be handled. And I'm just going to suggest there are a number of aspects of medical morality. Again, this is in your handout, so I won't spend much time on it. But there are some things about professional morality in medicine which makes it quite different than, say, armchair moralizing that philosophers do. Clearly, healthcare practitioners are responsible for the decisions they make. There is a weighty responsibility on their shoulder. They have to take the consequences for their patients and others, depending upon there has certain implications that they must take responsibility for. They're also held to high professional standards of practice. What would a reasonable practitioner do in such circumstances? And again, faced with someone who needs life-sustaining care, it's sometimes difficult to know what a reasonable practitioner would do in that circumstance. I think of Dr. Schulman's case several years ago when faced with Georgia Millette, who was in the emergency room, who was unconscious. Of course, you all know that case, where she had a card that said she was a Jehovah's Witness, but it was neither witness nor dated, and there was some uncertainty on his part as to whether it really reflected her true wishes. And of course, he was later held to have not obtained proper consent or to have inappropriately treated the patient despite her prior refusal of therapy. And clearly this also suggests another thing. Often our decisions aren't trivial. Who cares about the implications of a flu vaccine for a patient? But often what we do is not trivial for patients. People die on account of what we do or don't do. So again, a great responsibility lies with the decisions we make. And other people may be affected, not just the patient's family and the hospital in which we work. And the standard practice that has become defined over the past number of years is a patient interest standard, and I think there is a certain assault upon that patient interest standard that practitioners should take into third-party interests, and it's difficult to provide sometimes direction for physicians or other healthcare practitioners on when the patient interest standard may perhaps take second place to other considerations. Well, I wanted to look at a number of cases that raise some moral hazards for physicians. Some of these you may be familiar with, others not. A recent interesting case from California raised an issue about disclosure. This concerned, in Arato, this concerned a 40-year-old pancreatic cancer patient who agreed to experimental treatment after part of his tumor had been resected. He received experimental treatment. Most people with pancreatic cancer are dead within 5 years. It's a almost uniformly fatal disease, and up to now, no treatment has made any difference, whether surgical, chemotherapy, or radiotherapy. In this case, the patient hadn't been told that most people, he hadn't been told the exact statistics that 95% of people die with this disease, and consented or gave his agreement to the therapy, and he did die within the year despite receiving this experimental therapy, and the family later sued for negligent consent because he hadn't been told this piece of particular statistical data, and the courts were asked to comment, did the physicians involved in this care have an obligation to reveal this precise bit of statistical data? The physicians, by the way, had told him that most people with the disease die. They hadn't told him the statistics. And in their defense, they said, well, patients generally want to know the truth, and they acknowledged that patients don't want, in their words, a cold shower. So where's the difference between telling them data and a cold shower?
We'll make an exception.
Okay, thank you. What about the quality of life issue? I mean, is it
You mean, what if it was more
I'm
than...
going to have to, I've been directed to repeat questions for the
Yes.
purposes of the video.
Thank you.
The question is, what if it's a quality of life issue?
That's, I think, in part what that case was about, because the family was concerned not just that he had consented to experimental treatment without knowing this, but also that had he known the almost uniform fatality of this disease, he would have made other non-medical decisions about his life. And they wanted the courts to comment on that, that even irrespective of the experimental treatment that he agreed to, let's leave that aside, the physicians had an obligation to disclose this because of its impact upon his life as a whole. And the courts were asked to comment upon that as well. The answer is, and you have this in your handout, I'm getting a little ahead of myself here, the answer is the courts didn't find, at least in California, that by the doctrine of consent, the physicians had an obligation to disclose any information that related to non-medical matters. I don't know if that touches upon your question or not. Another case recently from BC, and this is similar to what we've already discussed this morning around confidentiality, concerned another sexual assault case, and where the defendant applied for the production of the psychiatrist's notes about the patient, and the psychiatrist, Dr. Parfit, refused it. And she said, to quote, "At all times throughout my treatment of the plaintiff, I assured her that I would do everything I could to ensure that none of our discussions would come out in public." And there are several reasons, of course, and these are classically visited in these cases of why she didn't want to release this information. She cited the possible harms to the patient. She might not return to therapy. She might lose her trust. Her depression might increase if not properly treated. There'll be harm to others. Perhaps if people generally know their psychiatrist notes can be subpoenaed, they won't come for treatment for a serious psychiatric disease. And also it implications for the physician herself that in the future she'll treat her patients differently. She won't keep notes as assiduously if she knows that her courts may be subpoenaed by her notes may be subpoenaed by the court. And again, so the moral question in this case is, ought Dr. Parfit to be required to submit her notes, and if she's so required, ought she to change how she conducts herself in the future with her patients? In this case, we've already dealt with this morning, so I won't spend more time on it, the R versus Ross case, which I agree is a very interesting case, because in the prior case, the defense apparently knew of the psychiatrist's notes and thought they might have had relevance to the trial. I believe that Dr. Hansen's testimony was not, or the evidence that he may have had was not known to defense, and hence they perhaps didn't know to ask him for submission of evidence. And the interesting thing in this case is that without being required to do so by law, he simply ventured to the Crown that he might have evidence that might be of relevance and left it at that, and then left it up to the legal process to decide his evidence should be considered in the trial. And it's created a lot of dispute in medicine about whether he acted appropriately in breaching the patient's confidentiality. And I've used this in several medical audiences, and the audience is usually evenly split on whether Dr. Hansen acted appropriately and whether they would do so if they thought indeed that a miscarriage of justice had taken place. Would they so disclose to a Crown attorney that they might have relevant evidence? And the last case I want to briefly look at is another interesting case which we may see more of in the future, especially as medicine is faced with more and more fiscal crisis, Law versus Samis et al. And this concerned a very complicated case who I can't go into in any great detail, but it was a youngish man in his early 50s who had a headache, a history of migraines, and had worse headache pain over several months on a number of doctors and specialists, and there was a whole rigmarole about who knew what, and was information passed on, and it wasn't always appropriately passed on. And the bottom line is this guy took over 2 months to get a CT of the brain, and which revealed he had a huge cerebral aneurysm. And then there was all kerfuffle about which neurosurgeon would do it, and there was referral back and forth, and before anybody operated, of course, what happened, the cerebral aneurysm burst and he died after emergency surgery. And one of the defenses of the doctors, and the family later sued for negligent treatment of Mr. Law, was that some of the physicians said at trial that they felt inhibited by the medical system to not use CTs for diagnostic tests and put it off, and the courts were asked to comment on whether it's appropriate, if ever, for physicians to use economic arguments to refuse potentially beneficial investigations for the benefit of their patient. So I want to look at some ethical implications of these decisions around truth-telling, around confidentiality, and I won't spend again much time on that because we have dealt with that. The duty to prevent harm, which I think is also raised in this case we've talked about this morning, and finally, I want to return to that physician as a resource allocator. So as I've mentioned already, at least in the Arato case, is that this was very interesting because the courts didn't find negligence in the physician's failure to disclose the 95% statistical risk of death. Actually, this case has been misreported, especially in the medical literature. There was a well-known article by George Annas, who's a well-known commentator on matters of medical jurisprudence in New England Journal of Medicine, who reported, for some unknown reason, the exact opposite of this, the decision of the Supreme Court. He said the court did require it. Well, a lower court required it. That was overturned at the Supreme Court level in California. And the courts didn't find as a matter of law that physicians had any obligation to disclose this particular piece, any particular piece of information, in particular this piece of information. And they weren't willing to intrude in the complexities, the context of the medical relationship. They did say that they were still using a patient-based standard of disclosure, but when it came to what evidence do we have about the patient-based standard, they went to physicians to say, well, what would you disclose in this circumstance? And I think the physicians in this case were quite lucky in that the courts used an expert testimony to decide about what would oncologists disclose in this circumstance. Would you tell statistical data to your patients? And they got some oncologists say, no, we wouldn't tell this because, blah, blah, blah. And the courts accepted that. And then the other thing that we've touched on already is that the court said, well, there's no duty to disclose information the patients might use for non-medical purposes. The family said if he'd known this, he would have foregone all treatment, taken care of his financial matters, which he never really did, and would have wrapped up his life more appropriately. And the court said the physician is not the patient's financial advisor. And I think that's a rather simplistic answer to really quite a complicated situation. Certainly, historically, if you look at, and actually I think it's kind of interesting because when you look at the practice of medicine historically, certainly, and this is again how the standards, ethical standards, legal standards change over time, certainly deception has been recognized as a part of medicine and accepted as that. Collins, a physician, wrote in 1927 that every physician should cultivate lying as a fine art, and he defended this quite assiduously, saying, most patients don't want to know the truth, and if they did know it would harm their interests, and therefore we shouldn't tell them, because of the old, do no harm argument, which has been raised by physicians still. There was an op-ed article in the Globe and Mail recently, I don't know if any of you saw it, by Dr. Kelton from Hamilton, saying that sick kids was wrong to inform parents that their children might have got Jakob Creutzfeldt through a blood transfusion. And of course, several parents are upset as well. Why do you tell me if you didn't know this was the case? And well, people are going to be upset when they sometimes find uncomfortable truths. And this physician said, the basic duty is do no harm. And if you're telling a truth that might harm, you shouldn't tell them. So, I mean, that's, I don't know, the argument was still here today. And the courts at that time also rarely found fault with physicians. There was a case from the UK in the early 50s where a patient who was a broadcaster was not told, intentionally not told by the surgeon, that she might suffer vocal cord paralysis as a result of thyroid surgery. And the court said, and she did suffer that consequence, and the physician, his defense said, well, I didn't tell her because there was this, there's this compelling interest that she not know this. He doesn't actually say what that compelling interest was, but that was, the courts accepted that, said, well, this is what a wise doctor would do, and the courts are not going to step in and tell wise doctors what they do in those circumstances. So courts have often deferred to medical wisdom. Of course, this has all changed with the modern notion of consent, and which came through the courts, but also has been accepted, I think, in medicine as well now, and not always that easily by practitioners, and that you have to disclose what a reasonable person in a patient's position would want to know. There are narrow exceptions to truth-telling, such as a patient's vulnerable emotional condition, but the courts have, I think, rightly recognized that these are a very narrow exception, and the test should be whether the disclosure would cause physical and mental harm to this particular patient. And the decisions, whether it's Bain or there's a BC case around abortion, have been extremely skeptical of physicians' claims that, in general, claims that the patients don't want to know the truth about their circumstance. And I think the better standard is one that has been enunciated by a physician many years ago at the turn of the century, Cabot, who said, you don't tell patients the whole truth, but you should try to create in patients, a true impression of their condition. That doesn't mean you have to tell them every aspect of their condition, but if there are essential things that they should know, then that's what you should tell them. It's not clear to me that the physicians acted properly in the Arato case. As I say, I think they're lucky in getting off that. Well, what about confidentiality? We've already discussed that this morning, and well, this is the Ryan case, which we didn't discuss, but a psychiatrist was required to provide the courts with her notes, and again, in this case, the court said the administration of justice outweighs that of privilege. By the way, there's a typo on that page. Did you get copies of the typos? Was that handed out at break? On page E8, first full paragraph, line 4, So line 4 in the first full paragraph, there should be, it says upholding the claim to justice should be upholding the claim to privilege. So that's page E8, first full paragraph, line 4, change. I've repeated justice twice in that. The second justice should be privilege. So basically, and the courts were not very favorable to Dr. Parfit. Said, well, you may have told your patient confidentiality was absolute, but you shouldn't have told her that. You created your own dilemma. You might have known, you should have known that that you might have been compelled to release your notes should some legal case come up. I mean, this is, for the poor physician to know this in advance, it reminds me of what my mother-in-law said when we found that we couldn't get our bed up our new house. She said, well, you should have known 10 years ago when you bought that bed, you might buy a house where you couldn't get upstairs, and you should have bought a bed that it could have folded up on itself, and like there's just no escape for it sometimes. In discussing with some physicians, these days, of course, medicine has changed dramatically. It's no longer the patient-physician dyad. There's a lot of people involved, and I've suggested to physicians, tongue-in-cheek, that sometimes medicine in the 90s, there's very few ways to ensure privacy. I haven't given this as legal counsel, by the way. I've just suggested that there's very few, there's some things you could maybe do to assure confidentiality of your patients. Unless you do these things, you're probably going to be required to release information. So provide separate exit and entrances for your patients. Answer only your own calls. Don't have a receptionist. Take no notes. Keep no records, and accept only cash. So I think then if they do these things, they might be found guilty of some professional misconduct before the college. So again, there's these rules don't work either. And again, this balancing that's already been mentioned this morning as important, that physicians have, there's a basic duty to respect confidentiality. There may be overriding reasons, and McCartney referred to the safety of individuals of the public, physical or moral. Now, I find that quite interesting, that last little phrase. What is the moral safety of the individuals of the public? And I don't know if anybody has an answer to this question here, but that would seem to me there's a big leeway open to breaching confidentiality for people. And Lord Denning, who, by the way, in that Hatcher case in the UK, said, we're going to defer to what wise doctors do, said that a judge is entrusted to weigh these conflicting interests, which is the confidence in the profession versus justice being done. And it's very difficult for physicians to know how to act in this case. And certainly the only case, again, that we know of where a physician has decided on his own to breach confidentiality and go before the court, do it publicly, has been Dr. Hansen. And I believe his license was suspended to practice for 3 months. We don't know the reasons this was made. He was charged with 10 charges of professional misconduct, the major one being breaching confidentiality. And he was found guilty of professional misconduct, suspended to practice for 3 months. I think this is now under dispute before the courts. And the question is, in this case, is the risk of jail to a potentially innocent person sufficient to warrant breaching confidentiality? And again, as has been referred to already, the reason to do so is the more compelling duty to prevent serious harm to others. In the U.S. Tarasov case, I think is important. Now, actually, the interesting thing about Tarasov is that many people were concerned about that as a precedent in medicine in the States. Was it going to change how, increase the standards to which physicians were held? Would there be the sudden decline in confidentiality? In fact, empirical studies have shown there's been no difference in how psychiatry is practiced in the States. And when psychiatrists are asked why this was, they're breaching patient confidentiality before the onset of Tarasov. So in fact, Tarasov articulated really what professionals are doing already. When faced with a dangerous patient, they did things to protect the public. Mostly those are clinical interventions, such as forming patients and so on, involuntary detention, stuff like that, for purposes of assessment. But in some cases, they were warning people already. So in fact, the Tarasov, while articulating in an explicit way this important concept of protecting the public, really didn't change the practice of medicine. And as has been mentioned already, there isn't any Tarasov-like ruling in the state, in Canada, although there have been several cases that are referred to it. In Ontario, the college has said something I found quite astounding, which is because there isn't a requirement to report crimes for physicians, physicians shouldn't do so. And the case that was referred to, and you can look at this in the proceedings of the college when the major spokesman of the college said this, it referred actually to a case where a therapist knew that his patient had committed or admitted to him that he committed a murder, which was similar to other murders going on in the area. And the college spokesman said the physician shouldn't disclose that piece of information. I found that quite astounding. When you think, well, a trivial crime maybe, but a major one morality, I think, would require you to disclose that no matter what your statutory requirements would be. In the last few minutes, I just want to go back to the Law versus Samis case, and it's a very complicated case I mentioned about, and the court did find negligence and carelessness among a number of the physicians, primarily the primary care physician and the locum doctor and an ophthalmologist. Really, it's about communication, and that's so important, and that there was a real lack of communication. People didn't tell everybody else what was going on, so the communication was a major focus in that case. And also the failure of various physicians to act on serious concerns that the patient might have increased intracranial pressure in a prompt way. But there's also a focus of the cases on doctor as a resource allocator. And the court said in this case that the financial interests in the system worked against the patient's interests. And when it comes to a choice between the physician's responsibility and individual patient, his or her responsibility overall medical system, the former must take precedence in a case such as this. So cost should recede in the background for the physician. And basically, it said, well, there might have been some financial harm to the system by ordering this extra unnecessary, might have been an unnecessary CT. In this case, the costs of the patient were much greater than any alleged costs to the system. So a number of rules could be suggested for resource allocation for physicians. And I won't go into these in any detail given the time, but patients are entitled to their fair share of resources. What does fair share mean? Physicians don't have to do anything conceivably possible for patients, but they ought to make sure that patients get any potentially beneficial care. It might be liable for substandard care or negligent care if they fail to go to the maximum for their patients in accessing potentially beneficial care. That if it comes to limiting care to patients, it should take place on the basis of professionally articulated standards of practice, clinical practice guidelines, evidence-based clinical standards, which are increasingly being articulated in medicine, and physicians should use those to decide upon what treatment patients should get. Physicians aren't economists, that they should avoid obvious cost considerations when it comes to decision-making for individual patients, and they should avoid unilateral, I'm going through this very quickly, I apologize, but there we are, it's all in the handwriting. Should avoid unilateral decisions, especially when physicians make unilateral decisions. That's when great difficulties may arise both for patients and also for physicians' legal interests. Clearly, another thing that's going to be important is avoiding potential conflicts of interest, which is a particular problem in the States where you've got systems of managed care, which in some cases have, as a part of the terms of employment, have said to physicians, you may not tell your patient that if they go elsewhere, they may get X or Y tests. Now, that has clearly raised great concern among some professionals in the States who are agreeing to a contract that is inhibiting the interests of their patients. And this created a great brouhaha that managed care may impact upon how physicians, not only what physicians do for patients, but also tell them about what's available. And finally, where there is, if a physician does believe a standard has been imposed solely to reduce costs and not in the patient interest, a physician shouldn't abide to those standards. Well, I'm not going to spend any time on this latter thing, just to mention some of the ethics resources in these cases. These cases are all difficult. They are not easy cases. There are a number of resources available to look at what the standard of care in medicine is. One is that there's a variety of articles available in the medical journals now. Every medical journal now carries ethics in a regular way, medical jurisprudence articles. Physicians are and should be aware of those articles. Many hospitals have full-time ethicists. They're in Toronto, and in fact, there are 4 or 5 full-time ethicists at various of the teaching hospitals. Many hospitals who don't have full-time ethicists have ethics committees, which cases can be taken and physicians can get help in resolving disputes. Formal ethics consultations can be obtained either through ethicists or ethics committees, and there also is now an ethics committee network in Southern Ontario, well actually in Southern Ontario, which hooks up many of the ethics committees, providing physicians and hospitals with other resources to help resolve disputes. There are limitations upon ethics as a discipline. There's a need for more critical appraisal, which we don't really have. There's a lack of consensus in some areas, and I think this creates great difficulties for physicians and other healthcare practitioners in knowing how to proceed. But I think this is an evolving area, and standards will be set over the next few years, providing more direction to healthcare professionals. Thank you.
Thank you, Doctor. Perhaps Linda and Richard, if you'd come back up here and we'll open up the floor to questions. Just give us 1 second. Perhaps if you can yell the question out, give me a chance to repeat it, and let me know who you wish to have answer the question. That would be of assistance. Sure, why don't you come up and use this mic, and I won't do justice to your comment, I'm sure.
My name's Jane Meadis. I'm the institutional advocate at the Advocacy Center for the Elderly. And I did want to comment on Linda Bohnen's discussion. I represent patients in these issues, and I think, as she sort of alluded to at the end of her discussion, that the patients group are not quite as happy with the Healthcare Consent Act as she probably is, and her clients are. The Act has taken away a lot of the rights of the clients, of the patients, for example, and given a lot of power to the healthcare professionals. For example, she discussed the exception regarding the little or no risk of harm in the treatment area. That gives a lot of power to the healthcare professionals to decide what is little or no risk of harm. The changes where the consent in the original setting, or the variations that you can just use that one consent, is great for the practitioners, not necessarily great for the patients. The treatment you get in a hospital you may not want to consent to that same treatment, for example, in a nursing home. There's a lot of difficulties that we have, specifically around the lack of requirement to advise someone that they have been found incapable. There is the section saying that there has to be guidelines. To my knowledge, there are no guidelines yet, so anybody that's been found incapable up to this point probably hasn't been told. And I frankly think it's unlikely, even with the guidelines in place, that the patients are going to find out that they've been found incapable. They'll just be taken off and treated. So although they have all these rights to appeal, et cetera, I don't think that they're ever going to actually use them, especially with now that the rights advice has disappeared. There's a lot of other issues in that act that are difficult for the patients. I disagree with Linda when she says that the act's easier to understand than the Consent to Treatment Act. I think you have to look at it very carefully. There are a lot of complications in there. And then specifically, just to make a comment on the do not resuscitate orders, although there are the immunity provisions, a lot of hospitals, nursing homes, et cetera, are getting people to sign DNR orders when they go in. And I think that the doctors and healthcare professionals have to be very careful on that, because getting someone to sign a DNR order when they're fairly healthy, which they're doing, is not getting informed consent. And I think that the healthcare practitioners can probably get into a lot of trouble for that. And I do have a question. I just wanted you to clarify the point regarding the placement in long-term care facilities pending appeal.
Sure. Let me do this. I was asked to clarify when an incapable individual may be placed in a long-term care facility for up to 90 days, despite their lack of agreement with that placement. And we were talking about, just in the break, about whether that was applicable only to crisis admission or not. And having re-reviewed the provisions, it seems to me it's not restricted to crisis admission situations because of where it's placed in the Act. So suffice it to say that if you are representing someone who either wants to place an incapable individual in a nursing home or a home for the aged, and the patient is contesting the finding of incapacity or seeking the appointment of a representative, or if you're advising the individual, read the section carefully to decide for yourself whether you think the person can be placed there for up to 90 days despite the application to the board. I think that they can be, but it may be open to interpretation, okay?
Any questions? Robert?
My question is directed to Richard. It's phrased narrowly, but it may apply to other places. Physicians who are treating other healthcare professionals who may be impaired, either due to alcohol, drugs, or mental capacity, do you have a view on like Ariscoff and David Pittman on the duty of the treating physician to guard the important place appropriate college and confidential? That's what their patients that stop their patients in capacity.
No, I don't have a view on that. I think that's a very difficult question. It would depend on the circumstances. I would think that you could apply Tarasoff on some facts and not on others. Now, some colleges have developed additional provisions in their regulations. For example, the medical laboratory technologists. But I don't think they require members to report another member who is in danger to the safety of a patient. But in your particular fact situation, I don't think there's a specific provision that applies in that context.
The questions? Yes.
Actually, my question is both for Richard and Dr. Hebert. You've both touched upon the question of competing interest of a miscarriage of justice versus confidentiality. How far do you, and I know, Richard, you said this is always changing and you can't really foretell where it's going to go, but where would you place an issue such as release of information because it's going to improve or our ability or the medical profession's ability to treat other patients? I've come across this where information has been requested by the Institute for Clinical Evaluative Services and or government agencies who say, release that confidential information because otherwise we may not be able to find a cure for cancer. Is there any, has it gone that way? Does anybody sort of recognize that?
Richard, since you were paying such close attention to the question, I'll have you repeat it and then you can answer it.
If you're asked to disclose information to help research in terms of finding cures for conditions or diseases, where does that fall on the balance of duty of confidentiality with the helping others? I would think that you could accommodate both interests by not identifying the patient. If you can release information in a way that does not identify the patient, I think from a legal perspective, and we've opened the ethical, from a legal perspective, you're probably all right.
And what happens if you cannot release that information, or the information can't effectively be used unless there are personal identifiers, so that you can't do that without releasing?
Well, then from a legal perspective, I think absent, a crisis like a worldwide plague, I don't think legally you can disclose that information without patient consent. You can go to the patient and ask.
The question there again was whether what you do if you can't do that without releasing the identifying factors.
Just before we get to the ethical response, of course, it also depends on statutory provisions and provisions and regulations. For example, in the current hospital management regulation patient confidentiality section, it appears that on a discretionary basis, information can be released for the purposes of scientific research, even with identifiers attached.
I was simply going to say that as well. My understanding, for example, that for purposes of the Cancer Registry of Ontario, the Cancer Registry is obliged, physicians are obliged to release confidential information, which may include the health number. So I would think that obviously that's a unique identifier. And again, the ethical justification would be, as you suggest, there is a broader social need and interest in this information without which medical progress cannot go forward.
What's interesting is that the reciprocal right is not necessarily accounted for. So in the case of the Ontario Cancer Registry, they don't have the right to pass on that information to another body like ISIS. Because, and as Linda points out, the doctors have the right or the obligation under statute of regulation, but unless that's followed through in everybody's act, somewhere the information gets done.
It's also a problem with the ISIS some of the ISIS data as well. They were concerned about what if they're in their looking at physicians' practices, they find a certain percent of physicians are practicing in a way dangerous to their patients. If they know who those physicians are, if they do have some unique identifiers, so we're not talking about patients here, we're not talking about physicians, is there some moral obligation to release that information in some way? And of course, as you know, in the States, that's happened. Practice patterns of physicians and practice and outcomes of physicians have been released, and you can identify particular physicians, surgeons, and their success, say, in doing CABG, coronary artery bypass and so on. And this has not been resolved yet, I believe, in Ontario satisfactorily. It's certainly a subject of great dispute, and many physicians, healthcare practitioners are concerned that data will be released without a full understanding of that data. So, as you know, some physicians may have worse mortality data because they've got sicker patients, and that isn't always accounted for in the release of the data. So it has to be very carefully done, I think, if it's done properly.
I think Linda has a comment on something that Dr. Hebert said.
Yeah, I just wanted to speak to the issues of physicians making clinical decisions based on health economic issues. I think that in Ontario, as long as physicians are able to stave off directly managed care, the locus of dispute and of litigation will be shifted to the hospital, because hospitals are under tremendous pressure to reduce lengths of stay and to stay within their budgets. And they may, in fact, be the decision maker in terms of who gets access to a particular service, who gets turfed out of the hospital, and impose these decisions on the physicians who have privileges to practice in the hospital. So although the patient will not have a cause of action against the physician for having failed to make arrangements for a CAT scan or whatever it might be, there may be a cause of action against the hospital for having prevented the patient from obtaining a service that might have made a difference. I know that hospitals and insurers are certainly concerned about the effect this may have on their on hospital liability.
One issue that raises, I suppose, is whether or not there may be a cause of action against a physician for failing to advise of alternate availability. For example, Mr. Smith, we'd like you to have an MRI. The waiting list is 6 months long here. You can have it tomorrow in Buffalo for $1,500. And is there an issue there as to whether a physician has a duty to tell the patient of that option, recognizing that perhaps it would be in that patient's best interest to have the MRI tomorrow rather than being put on a list?
Could the doctor respond to that?
I suggest they read the Globe and Mail. They can find out about MRIs available in Buffalo. How great an obligation is that? I mean, do you have to, I think if you know that there's some potentially beneficial care that the system, the local system, is denying patients access to, you probably do have some obligation to tell your patients that. And I certainly do that. I tell patients, faced with, some potentially serious problem, there are other ways of accessing this diagnostic, whatever it is, care. Most patients don't avail themselves of those opportunities.
Yeah, and how do you distinguish between those patients, have the money to do that and those who don't? And does it make sense to say to a patient who is a welfare recipient, for example, that for $1,500 you can go to Buffalo and have your MRI, and I think that would be a good idea when you know darn well they're not going to be able to afford it? Another question?
Follow up to that. There are medications that have a very good effect on certain treatments that the Ontario government has not seen fit to approve. They basically have instructed doctors and hospitals not to prescribe these medications because they're not approved by the Ontario government. How do you feel about doctors not advising their patients that these drugs are available?
Of course, it would depend upon the drug in question. I mean, a practice that comes to my mind, I see a number of HIV patients, and there's some medications in dispute there. I tell patients, there are this medications available in the States. We can't access it here, although what I do in those cases, there's a Form 8 that I can fill out saying to the government, apply for special application that the government may cover. So, I tell patients that and I try to do everything I can to access these for patients. I think how far physicians have to pursue that is another question. It would depend upon the particular drug. I think if it's known in it's one thing if it's written in some obscure journal that there's a medication might help, but if it's well known that there's medications might help and the system's denying it, I think there probably is some obligation upon physicians to tell their patients that this potentially beneficial drug has been denied to by the system. And, whether the physician can do anything about that's another matter. But I would think there's some obligation to tell patients these are available.
Any other questions? Right, well, thank you very much for coming out. We hope you profited from a little bit more knowledge as to what's going on in health law, and certainly an up-to-date viewpoint. I'd like to thank all of our speakers for coming out and participating today, and really think we learned a lot from them. Thanks. And hand it in.
We were all excellent.
Thank you, Council.